biggest mistake people make after a DWI arrest in Houston isn't getting arrested in the first place, it's what they do afterwards. I've seen completely defensible cases turn into convictions just because of bad decisions in the days that follow. So if you're facing a DWI in Harris County, these are 5 things that can quietly destroy your case and how to avoid them. First, not requesting the ALR hearing. Let's start with one that almost everybody misses. In Texas, after DWI arrest, you have 15 days to request an ALR hearing. If you don't, your license gets suspended automatically. You lose a huge opportunity to gather evidence. That hearing isn't just about your license, it's a preview of the state's case. We can question the officer under oath, lock in their testimony, and identify weaknesses early. If we miss that window, you're topic number 2, refusal versus blowing. Which one is worse? People always ask, should I refuse a breath test? And the honest answer is, it really depends. Refusing will trigger a license suspension, but it limits the state's evidence. If you do decide to blow, it gives the state a number to use against you, but it may avoid an immediate suspension issue, especially if you're underneath the limit. If you consent to a blood sample, it's going to avoid that suspension until they get a number. If it's over 0.08, that's when the suspension would kick in. In Harris County, both scenarios can be defended, but they require completely different strategies. There's no one-size-fits-all answer, and what you did matters a lot for how the case is handled. Blood warrants, what the police can do now. Here's something a lot of people don't realize. Even if you refuse, police in Houston can often get what's called a blood warrant. That means a judge signs off, your blood is drawn, sometimes at the hospital, sometimes at a jail. And then this is where it gets interesting. We look at, was the warrant valid? Was it executed properly? Was the blood handled correctly? Chain of custody issues, lab errors, timing problems, these can all create defenses to a DWI. Then there's the normal use of faculties cases. You don't actually need breath or blood tests to be convicted of a DWI in Texas. So even if you refused and they did not get a search warrant, they never got your blood, they could try to prove that you've lost the normal use of your mental or physical faculties. This usually comes from officer observations, field sobriety tests, video footage, but it's one of the most defensible type of cases. Why? Because it is subjective. Jurors will often question, was the person actually impaired? Or maybe they were just nervous or tired or confused by the way the officer was doing the instructions. These cases are often stronger for the defense than people think. And let's look at the reality of Harris County courts. Not all DWI cases are treated the same. In Harris County, some courts move fast. Some are more negotiation friendly. Some prosecutors are more aggressive than others. And we have to understand the specific court we're in, the assigned prosecutor, the judge's tendencies. All of those things can have a huge impact on the outcome of your case. This isn't just about the law. It's about experience in the local system. So here's the truth. A DWI charge in Houston is not just about what happened that night. It's about what happens next. The strategy, the timing, the decisions that you make early on, that's what shapes your case. And if you're dealing with a DWI in Harris County, don't wait until it's too late to take it seriously, because the people who get the best outcomes are the ones who act early and act smart. I'm Brian Foley with Houston DWI and criminal defense attorneys. Don't forget to like and subscribe for real strategies, real cases, and what actually works in Harris County courts.